Welcome to the Wellness and Legacy Group. We are a networking group that is geared towards connecting death care professionals. So we are happy that you're here. We are a group that meets locally in Ponte Vedra, and I want to give a shout out to our lunch sponsor, Ashley Phillips. From Comfort Care. She is the owner and operator, and they do all things of helping the families in their home to age in place, and she's amazing. So definitely get to know her. Today, I will be your host, Carolyn Castillo, and we are proudly representing Probate Property Angels, where we help families with inherited properties. So reach out to Holly or myself, and we'd love to speak with you and anyone you know that may be in need of this. So for those of you that are just joining us, that is the first time, this is a good-looking group that we have here locally in Ponte Vedra. We get together once a month, and it's all people from the death care industry. Now, we have a vision and a mission for this group of creating a seamless connection between the wellness industry, which serves individuals prior to death, and the legacy industry, which supports individuals and families post-death. What we recognize is that both sectors often serve the same customer, sometimes simultaneously, and our group aims to foster a deeper understanding and collaboration across all these critical stages of service, ultimately to unite our industry together. So this is what we've put together as a bird's eye view of the death care industry. There are lots of little niche industries within our space. But we basically broken it down into the core elements of everyone knows one day we're all going to die. It's a reality. It's the birds and bees of life, right? And if we know that to be a 100% fact, then there should be proper planning put in place. So we've broken it down into financial planning, estate planning, funeral planning, insurance planning. We have successfully completed interviews with all professionals in this field. John Miller today is literally putting the cherry on top of the cake for pre-planning, okay? So we have effectively made it through the entire pre-planning series. And after John, we're gonna be deep diving into what senior advisors do, what are the real estate home services that are available in the community, hospice providers, and then we'll be going over to the other side, okay? Once you do pass away, what is the post-death administration? What does it look like to actually go through a funeral, to go through probate, to go through a trust, okay? So there's gonna be a lot of interesting things, and ultimately today you're here because you want to be a part of the mastermind. When we got together for 1 hour on a lunch, it's not that easy to break down the entire death care industry in a 30-minute lunch that we have together. So we spun this off to get together once a week, interviewing our network's professionals and really finding out what are the best practices. So without further ado, I will go ahead and introduce our amazing guest today, John Miller. Let me bring you to the stage. We're going to pin your video here. Let's go. We've got the amazing John Miller from Rock Title and Law. And today he does many things, including a professional guitarist and musician. So don't get it fooled. He is a rock star, okay? On top of that, today he's going to be bringing his knowledge about how we can transfer real estate, avoiding probate, and the best pros and cons of transferring real estate when you're thinking about if you were to pass away. Okay, John, thank you so much for being here, sir. Welcome.
Good morning. Thank you for having me.
Thank you, John. Well, we can just dive right in. We already kind of did, some discussion prior to this. Really what this topic is to talk about what options we have. When you buy real estate, there is a deed, there is a title, okay? And the deed and the title is what is actually being transferring it to somebody else in the event that you should pass away. In the event, right? Well, when, right? That's when it happens, how will your real estate transfer? And there's a couple different options in Florida. And maybe we could just start it off with the basics. In Florida, if you're a husband and wife, right? Let's say you're a husband and wife in Florida, you bought a real piece of real estate together. It's probably the simplest answer we'll start off with first. What would be the best way to title that real estate so that it would effectively transfer to your spouse in the event that one of you should pass away?
Well, sure. And thanks again for having me here. I started in the real estate area of the law in 1991, 6 years into my practice. So I've got a few minutes in this. And we always want to think, okay, what happens if, right? And so typically, and a lawyer's favorite answer to every question is it depends, right? So I'm going to start with that because it depends on whether that couple has a revocable living trust or not. So let's just assume not. Let's assume this is a couple that's newly married and they're acquiring their home. And let's first off go with homestead, right? Because Florida homestead is really special. We could fill a whole hour with homestead, but we won't do that today. But just know that that is really a particular thing. And I know you guys as real estate specialists know about homestead. Not everybody does. But our homes in Florida are very well protected. And in fact, even if a spouse's name is not on the deed, if it is a couple's homestead, the non-mentioned spouse immediately has an interest in that home. And that is a life estate, meaning that even if the person who was on the title, in the olden days, it was typically the man, and if he died, the surviving wife didn't get kicked off the property. Believe it or not, even in this century, I have heard of uh, adult children saying to the widow during the funeral weekend, "Well, when are you going to move out of dad's house?" Well, my answer to that is when she gets good and ready or when she dies, because she has the right to stay there her whole life. So,
So
yes,
when it comes to husband and wife,
yep,
they're just buying their first home like a
yep,
regular, real estate closing. Nobody's thinking about dying at that point,
yep,
okay?
right,
And let's say that it was both husband and wife, or it could just be wife's name on the title. Husband doesn't have to be on it. It's deeded into her name or it's deeded into both of their names. In
right.
the event one of them were to pass away, the title would just transfer to the living spouse.
Automatically. Yes.
Automatic.
And in fact, I've had that this week because there was a home insurance refund. The husband had died and the check went to both of them. And so the insurance company said, well, maybe you better deed that to yourself. Well, it was really unnecessary. And they actually had worked it out before she got to me, um, because she submitted the death certificate. And so the check was corrected so that she could deposit it because obviously being a widow, her husband wasn't available to endorse the check and couldn't deposit it in an account. So
Mhm.
it is with rights of survivorship, certainly on the homestead. Now, a married couple can also buy real property that's not their homestead. And in the old days, we'd put John and Carolyn, comma, his wife. We don't do that anymore. We now
I
put
noticed.
either husband and wife, or more commonly these days, a married couple. And when you see those words, that means there's rights of survivorship for the couple. Any of those words will suffice. It's just that we've tried to clean our language up a little bit over time. And I will say this, for us lawyers that studied real property in law school, it is some of the most ancient of law. And our US cases will even reference English common law because that's where our laws come from. Unless you're in Louisiana, then it's French, but we're not in Louisiana, so I'm not going to talk about that.
Mhm.
And that's how the law came down and established. And then in Florida, we have this strong homestead that the surviving spouse is going to have an interest in that property. Now, better to put it in both names, right? So it causes less problems for the survivor. But
Mhm.
with a little bit of legal help, that surviving spouse is going to be able to stay in the house for life. Now, most couples would really want that home to be available for whatever way the surviving spouse needs it. Let's kill off the husband, okay? And so we've got a surviving wife, and there comes a point in time where she doesn't need that house anymore, and maybe she'd like to go into an elder living community of some kind and could use the money. Well, if she only has a life estate, she can't sell that without her children helping her and signing off, permitting her to do it, if you will. So you've shackled her with the whim of the children, the heirs, and so better to have her on that deed. So after he dies, she's in complete control during her life.
And that in a sense, as long as when they took the deed, it said married couple, wife, something of that language, there really wouldn't have to be anything further. That property is going to transfer right over into the spouse's name, correct?
That's correct.
Now, let's take it the next step. So if now she's a widower, okay, now she owns the property by herself. There's nobody, a husband or anybody to directly, benefit from this. So now, someone may say, well, when I die, I want my son to have the house. What would be, the best if she knew that now she's a widower, how should she now title her property so that it could transfer smoothly?
Right. So she's going to want to talk to a lawyer who's versed in both estate planning and real property, and they're going to together make the best decision. In former times, let me say it that way, often to have this ease of transfer on death, even a married couple or a widow, as you have suggested, would add their kid onto the deed, right? Now, there are a number of problems that can arise by doing that. First off, let's make the son a bit of a ne'er-do-well, and if he gets a judgment against him, maybe that property is going to stand against that judgment, especially after the widow's death. All right. Also, you've got a step up in basis issue with that too, so there's a tax problem with it. But really, if I'm talking to that widow that you just described, we're going to talk about two paths, and she is going to choose. And really, it's, do we create, if there was not one with the husband, a revocable living trust, or do we do what's nicknamed a Ladybird deed? And the fancy legal term for that is enhanced life estate deed. And I'll talk about that in just a second. We might consider the trust for somebody that has a higher level of assets, and it's worth it to her to go ahead and do all the planning in that one trust. And people ask me, well, how much is it? And the answer is it's up to every individual whether they think they have enough assets. But honestly, you get $300,000 to $500,000 out there to be treated to keep out of a probate proceeding, and a trust starts to become a good idea.
Would
So
you
if we did
consider the
that
real
trust,
estate, would you consider the real estate as part of that assessment or no?
so I do in my brain count it in, but you know what land prices in Florida have done. So I like to say most of us are sand millionaires these days, right? Just because the value of our homes have gone up. So we can treat the home in a way that keeps it out of that analysis. But in the big picture, I'm thinking about it at first, and then I'm thinking, okay, what are the exceptions that we might not need one? Because candidly, an estate plan that includes a trust is about double one that doesn't, that's just a last will and testament based, or, a couple or a few $1,000s difference depending on what's being created. So if you did create a trust for a good reason, well, you'd put that homestead in the trust. People, oh no, I don't want to lose my homestead rights. Great question. Florida has a specific statute that says that if you move your homestead into your trust, especially your revocable trust, then you don't lose any of your homestead rights. It's beyond today's scope, but there are irrevocable trusts that we can put homestead in, but that gets tricky. And usually we're trying to accomplish some other greater goal in that process. So that's easy because you put the title in the trust, and then inside the trust, you say you want what happens to that homestead. Now it could be I want Billy to have it because Billy lives here and all the rest of the kids are elsewhere. But I don't think that's fair because I want to equalize the rest of the estate. So that's got the value of the house is going to count toward Billy's share, and we're going to use our other assets to make the other kids whole. One possibility. They don't have to make the other kids whole. It's their trust. They can do what they want. Another is just leave it in there as part of the estate. Whoever's your successor trustee, it's often one of your children or it could be a professional, then says to the kids, anybody want it? And that one would then be in a position of buying the others out to take possession of it. Or if they all agreed, nope, none of us want that, it just gets sold. The cool thing is the trust doesn't go before a judge. So you've eliminated probate there entirely. And the heirs, the kids, get immediate access to that real property, to that asset, and get to determine what to do with it now rather than paying the taxes, the insurance, and all that for whatever period of time the probate goes on and having it come out by a judge's order. We can get back to that judge's order if you like a little later. So that's the trust way. There's another way that works equally well.
Let me
Yep,
break
go.
it down real quick. Yeah.
Mhm.
So when you're looking, so like myself, I'm familiar of looking at tax records or just seeing how, things are deeded. So if we see on the title that it is a revocable living trust, so you see it how as it's titled in the
Mhm.
property ownership,
Mhm.
then that is saying that there is a trust agreement in place, and inside of that trust agreement, the homeowner has said, I want it to be sold upon my death. I want it to be transferred to my living children. I want it to be transferred to only one of my child. Forget about the other ones. Are all of those correct?
Yes, possibly. So the deed is going to be into the trustee, probably your name, comma, trustee of the your name revocable living trust, revocable living, whatever you decide to name it. And then the title is actually held analytically in the trustee, who is the fiduciary for the trust. Inside that trust, it may say any of those things you defined. It could also not specifically reference the homestead at all, because then that just becomes part of the residuary estate and is split up in whatever way that grantor decided to say that the assets are going to be split between their beneficiaries.
So
But you do know
it could
it is
be
in a trust.
the real estate could just be added into the trust without specific language on how to actually administer it.
Absolutely.
Okay.
Yes.
So it could just
Yep.
be generalized, like you're just adding the asset into your trust, and then the beneficiaries of your trust are, your four children, and the property would then be transferred into their names.
Yep. Yep. It could be, but you've made the trustee in charge of how it's going to be, because you've just identified one of the problems with probate that I know you've seen before is that order is going to come out of there to all five kids if there are five. And now you're going to have to get five people to sign the deed. And as we so often see, one of them's in jail or one of them's living, somewhere unreachable on the other side of the world, right? Off the grid. And you got to track that person down and get them to properly sign something so that the property can even be sold.
Yeah, I was curious about that. So if they haven't appointed a specific trustee to administer over, and it doesn't specifically name that one person, then everyone has to be involved the same way.
Mm, so probably let's just take you. It's the Carolyn Living Trust. Okay. You're going to transfer your home into Carolyn, comma, trustee of the Carolyn Living Trust. All right. So it's not really you as an individual that takes title, it's you as trustee. Now, I'm sorry to do this to you, but your days are done. But in that trust, bye bye, you have named um, Holly. Holly is your successor trustee. So as soon as you're unable to be trustee, Holly is the one who is in charge of that. So if you have written a rule on how it's going to be transferred, Holly will have a fiduciary duty to transfer it that way. If you've left it as part of the residuary estate, you spelled out for Holly how she's going to split that up. And then she's going to communicate, most likely, with the beneficiaries, the people you've named to benefit from your treasure after you're through with it. And then they're going to say, sell it, give us what's left. Or little Joey wants to buy it, so take the other 2/3 out of his share and give it to his brother and sister, that kind of thing. So it's actually the trustee, incapacity of trustee, that takes title.
Right. This is probably a technical question, but at being a title company as well, right? So you know about title insurance. If that house is brought into the trust and it's Holly is the trustee, she is to, speaks with the members of the trust. Is everyone in agreement to sell? Yes, we're in agreement to sell. Holly administers to sell the property, right? Then when it comes time to sign at closing, would not all those beneficiaries have to still be signing to transfer over their share in that?
Not necessarily in the trust if it's written correctly.
Okay,
Yeah.
yeah, that's the
Now,
key.
title companies do often require other beneficiaries to sign. And I'm sure you've seen that's why you're asking this
Yeah,
question. And usually there's an issue either with the title itself or with the terms of the trust when that occurs.
right.
So, and they're belt and suspenders, they're trying to protect themselves and the new homeowner as best they can.
Mm-hmm. Okay, so that's really kind of almost legalese. Like that's probably way deep for everybody else that's not involved in real estate or title. You're like, what are you guys talking about?
Yep.
Let's get more to basic lands. Okay, so obviously we can go into a trust. We can have our states, but let's pretend that we don't have a trust. Let's pretend
Okay.
that we're not setting up a trust. So we talked about how a husband and wife would transfer. Do you want to go start into maybe talk about the joint tenancy of right of survivorship, where it's not a husband and wife, right? But you've taken title with this person that in you're living with them, maybe it's a boyfriend. Why do people put their properties in joint tenancy?
Sure. So there can be a choice whether there will be a right of survivorship or tenants in common there. And
Okay.
that's a really important thing for people to remember. Happen to be dealing with that one right now. Adult children contacting me, their father's significant other. It's so hard to use girlfriend when they're in their 80s, right? But passed. But they were holding it 50-50 in common, which means his half is his half and her half is her half. So in this situation, it's great because everyone agrees and he has the assets to do so. He's going to buy out her heirs. But it isn't always the case because they would own half of his house. And if they can't get along, they could ultimately force the sale of a house that he didn't want to sell, right? But the in that regard, each person owns their half separate from the other, and it descends however they want to. They can actually even transfer it during lifetime to another person. So you can imagine problems that would cause when there's been a transfer to somebody that the other 50% holder doesn't like, right? So
Right.
you have to really think about this thing. You can have non-married people own property together, obviously, and agree to right of survivorship. If I die, I want you to have this. This is ours together. I want you to have it completely. But maybe there's somebody that got together later in life and each has grown children of their own. So that might be why you'd split the tenants in common. Or you might consider a trust in that case that could deliver the property. Now, and this is a little off the subject you just said, but it's also we don't have a trust. We're not going to do a trust. We don't want a trust, or we don't feel we have the assets, or we don't want to spend the money, or for whatever reason, we're not going to do a trust. Gosh, what else can we do to keep this thing from dragging through probate so that our heirs can call you, Carolyn, and say, hey, let's get this thing on the market. as soon as possible after mom and dad die. We are fortunate in Florida that we have a deed that's nicknamed the Ladybird Deed, and I know you're familiar with this. Its formal name, when it puts on its tuxedo, is Enhanced Life Estate Deed. We talked a little while ago about a surviving spouse, even if not on the homestead, having a life estate. That means you got the right to live there. But that's all you have is the right to live there. You don't have the right to sell it, to mortgage it, even to take a HELOC if it needs repairs of some kind. Okay. So enhanced life estate deed says, yeah, when I'm done with this, I want my whoever, but I'm going to go with hypothetically 2 kids. I want both my kids to inherit this equally. Okay, cool. Now, you know, my one child I know will do whatever I say, but the other one, I'm just not sure whether they would do what I want. So I want to maintain complete control through my lifetime. Complete. I want to be able to sell it if I choose to do so. I decide to go live at a assisted or independent living, and I just want the money. I don't want this house anymore. I'm going to sell it. Or mortgage rates have dropped again and mine's too high. I'm going to refinance it. Or I got to get a new roof. I don't have the cash on hand. I'm going to just take a little HELOC loan. By executing this Ladybird or enhanced life estate deed, that person keeps complete control over the property until the moment they die. At that immediate moment, the heirs, whoever they've named, in my case, it was the 2 children, uh, become the owners of the property. And I've confirmed this with property appraisers, they get a step up in basis. So should they turn right around and sell it, they don't have to have mom and dad's basis of 28,000 when they bought it in 1962, right? They get the value at the time the last living parent died, and then they only have to pay the capital gains on the amount they sell it above that, if any. So it's not one everybody knows about, and it's only available in about a dozen states. It's Ladybird, by the way, because President Johnson's wife, Ladybird Johnson, her smart lawyers came up with that. And I presume it was after he's gone because it's not the Linden deed, it's the Ladybird deed, right? So
Okay, that's
I
interesting.
don't know the actual answer to that, but I know it's like having some magic fairy dust. I often say we didn't get a magic wand when we got our Juris Doctor after law school, and we can't pull a rabbit out of a hat, but every now and then we do get a little bit of ability to make some kind of magic things happen. And it's incredible the difference to a family in having a Ladybird deed there to transfer that property than having to go to probate court with
Right.
it.
So
Mm-hmm.
the Ladybird, that is, it's a wonderful tool. And when do you think somebody would execute something like that? A Ladybird.
Oh, as soon as they know who they want to inherit it, right?
Okay.
Because I don't really see a downside.
So
Um,
it doesn't encumber the person that you're putting on it, like we had previously discussed, as far as them coming up in the HELOC or you getting, their liens or their judgments coming against your property. None
right.
of that would happen.
It protects from that, and which is why it's better than quit claiming your kids onto your deed. Um, they are typically, and sorry, ladies, but real property law is slow to change. They're called remainder men. I have heard somebody use the term remainder person. I kind of like that. It's a future interest in real property. It's not a present interest in real property, meaning that interest is only contingent on the grantor still owning the property when they die. So it's not an interest at all until that person has taken their last breath, and then they automatically become the owner.
So the Ladybird deed is recorded with the county,
Of course.
right? It's not one of those deals that's your top drawer. You've got the, it's not
Don't
the
do it.
top drawer deed, is it?
No, it's not the top drawer deed. Don't do that. Because you'll
Um,
have title issues with those kind because there'll be a gap from when they're executed to when they're recorded. And it's the recording of the deed that gives the certainty of the new ownership. We have to have that. You can't have top drawer deeds hanging out there and somebody give money for a piece of real property now, can you? So um, it is the actual recording of it, and it is part of our practice, and every good other good attorney they're going to record that deed for you and have it returned to you.
How would it show on the property owner, in the county? What would it show that you had a ladybird deed in place on that property?
It's got a special name, and I just looked at one. Yes, I think it's a special warranty deed, and then
Mhm,
underneath it, it usually says enhanced life estate, so it's
mhm.
identified right from the top. There's also some um, particular language which needs to be included in that deed. So this is truly not a I stayed at Holiday Inn Express or whatever it is, and a self-help item. This is one I would truly want to tell people you need to have a knowledgeable practitioner, an attorney on your side for this thing.
No,
It also is going to have Florida homestead language in it, right? Which is really, really important, which, by the way, has to be in a trust in order to keep homestead alive in Florida. So when we have uh, new Floridians who've moved in from another state, it's really important that they get their trust updated before they put their new homestead in the trust so that it does have homestead language and they don't lose their homestead, because that can be catastrophic on multiple levels.
can you use a ladybird deed to, disinherit? I'll just say that. Like, can you make a ladybird deed life estate and say it is to go to, and just name one of your children, let's say, or even the Humane Society or whoever you want your property to go to? Is that an option with the
Abs-
ladybird deed?
Absolutely. Yeah.
And that
Um,
is that contestable or?
in America, everything's contestable in court, right? So duress, undue influence, those kinds of things. But
Right.
once that is recorded,
Means
it's a very high bar to have that set aside.
so the family member, whoever would be the beneficiary of that, they would just, once the death certificate is filed, then the deed would just be updated into the.
No, they don't even have to update the deed. But they might, right? They
Yeah.
might. Let's say I inherited through that method. Well, that's not going to be my homestead because I already have one. So I'm going to talk to my smart lawyer and go, what do I do to asset protect that? And he or she is going to say, well, let's form a multi-member LLC and transfer the property into that. So I would probably transfer out of the Ladybird my interest into that entity. So then I could rent it and have some asset protection against the tenants and their guests in my home.
Hmm.
And if I had a trust, I'd own that LLC through my trust. So, we're creating multiple layers of protection for them.
So people can use a ladybird deed, like if you know that your loved one is going to be passing away, in either imminent, like this can be something that can really help families to transfer that real estate without having it go to probate and not even having a trust in this situation by using the ladybird deed.
100%. Yes. Yeah. And that's often when we use it. Um, it can be sad. Somebody's gotten their diagnosis, but they're realistic. And as you said, nobody gets out alive. So they're like, all right, let me make this easier on my heirs, then harder on my heirs, and I'm going to execute this deed. So when I'm gone, it becomes theirs.
Hmm.
Yeah.
Hmm.
Because,
Yeah.
and you know this, but I don't think most people do. Uh, in Florida, homestead is exempted from the probate estate. Well, that sounds wonderful until you know that in order for a homestead to be outside of the probate, you have to file the probate, even if there's no other assets that need to be probated. So the judge can look at it and go, yep, that was their homestead, and then enters a homestead order. And then that moves it outside the homestead. Although some of the judges are now not entering that order until after the 3-month creditor period runs after publication. So already you're 6 months past death before you even have a chance to get that order issued. And that's going to issue again to all of the heirs, either by will or by intestate. So you think, oh, it's not part of the probate estate. Well, it's not technically. but it has to go through probate to find out if it's not part of the estate. Then once they're in probate, they're stuck. They got to follow the whole probate process to get that final order to get out, so the court no longer has jurisdiction over them.
Yeah,
Yep.
that's the hilarious part.
Yep. Yes. It's a what?
It's not a probated asset. However, in order to get it, you've got to go through it.
A
So,
judge has to say so. But if they had a trust or if they had a ladybird deed, those are not issues.
right, right.
You
So
would.
I really can't think of why anybody wouldn't just want to do a ladybird deed. It just seems like such a, your husband and wife, it's deeded together. If you know who you want to transfer your assets to, you have the ladybird deed in place. But then when you talk about different, I guess, family dynamics, I'm actually working on a case for myself right now, exactly what you were talking about. It was a boyfriend and girlfriend, right? That got together in their 70s, 80s, right? And the wife, or the girlfriend, she owned the real estate. They started living together and they made a decision that each person, whoever would die first, would have the opportunity to live out their life in that property. However, once the final person would pass away, then each of their, because remember, they're older, so she has her kids, he has his kids, that then would be able to sell the asset. So I started working with the mom that she had passed away and the property got transferred into her two sons' names. So now you look at it, it's the two sons' names with the estate of, right? And the person that now has passed away. So they're 50% owners with somebody that's going through probate, right? And I think
Right.
mom and dad in their minds, they had it all figured out, but if what about that situation if, they're not legally married, it's two people owning a property, what would be the best way for them to, they want to secure it that the other person can still live there, live out their life there, right? I think most people in a good relationship, that would be their desires, but then it's two separate families um
Right.
that would inherit the asset.
So she owned the property at the beginning. So
Mm-hmm.
she's the only one who can execute whatever deed will be the answer to their conundrum.
Mm-hmm.
Um, she wants him to be able to live there if he is the survivor.
Mm-hmm.
And so she will want to give him a life estate, not an enhanced life estate, because she doesn't want him to be able to transfer it or it be part of his estate, but he just has the right to live there. In her case, she can leave, she could take the enhanced life estate, which means she would, if she's a survivor or anytime, she continues to completely control it, but subject to his life estate now. So she can't do that until he's not alive anymore. But then she could name her own kids as the remainder persons who would inherit the property. So
Mm-hmm.
I've actually had that one before also. It seems like, really? We both have that, but it's not that uncommon because
Right,
a
it
lot of
really
people,
isn't. Yeah, if you think about it, lots of people get together in the older years. They've already acquired their wealth, they've already acquired their real estate. Now they're coming together. What's the best way to shimmy shoo it?
and they've had their long, successful marriage through which they raised children, and that's great. And they just, uh, they don't see a need to get married in this day and age. And, if that's their choice, I think we have to respect that. And then we throw the I'm a preacher's kid, so it's hard to say, but the church out, right? You're not talking marriage here, but there's still the legalities of
Mhm,
it. So let's tie those bows so nicely that it gives everybody what they wanted and need, and then ends up in the right hands. So it's a great example, and it's not an easy fix, but it absolutely can be accomplished, and without a trust too.
mhm, mhm. So it would, they would, the life estate, I think, is what I'm hearing is the life estate is what will transfer, will keep all the control, but not transfer to anyone besides a spouse. Or did I get that
Uh,
wrong?
the
The
life
life
estate's only the
estate,
right to live there, so that's what the boyfriend would
the
get.
right to live there,
Yeah.
right?
The
Yeah.
girlfriend who already owned it and wants her kids to have it after his turn, she's going to keep complete control of it through the enhanced life estate. And it's just that one little word enhanced, but it's a big, big difference. It's a special statute under the
Mhm,
Florida code.
mhm. But hypothetically, if two older people get together and they've got their own wealth and they've got their own assets, I mean, it'd probably be best to have like a prenup, right? That has things identified.
100%.
Uh,
Yes.
or
Yes.
also just setting up a specific trust for the real estate, right? So that they could have it administered in a way that would make sense for all parties.
Absolutely. And that could be a revocable living trust, or it might be better to use a Florida land trust, which is a whole nother vehicle we haven't touched yet, but which
Mhm,
is a very special way of holding real property
mhm,
and controlling it. Um, since I have practiced a very long time, I remember before we had living LLCs, limited liability companies in Florida, we didn't get those until 1999, and then there was a mess up in the statute, and you couldn't have a single member one for the first year until the legislature fixed it. So before 99, we used land trusts a lot
mhm,
as a way of holding property and controlling how it was going to be distributed. And then post 99, because of the informality of the LLC as opposed to the sub S corporation, we began using LLCs a lot more. About 10 years ago, some law developed which made single member LLCs not as strong an asset protection device as they had been. Multi-member LLC is still the case, but not everybody has somebody they'd like to give an ownership interest in their LLC to. So the land trust became more popular again, and we're seeing many more of them used in the last 6, 8, 10 years than we did for a good 15, 20-year run there, where just everybody popped everything in an LLC. But there's a real analysis that needs to take place. So with your boyfriend, girlfriend, aging significant other syndrome, I was once told there's a French word, it's either possil Q or tossle Q for that, but that doesn't really help us out much here. I always wanted another word than boyfriend, girlfriend, because it just doesn't work well. But uh,
and
thankfully, I'm happily
the
married,
kid,
and yeah,
yeah, the kids are always unhappy around those arrangements,
right,
Uh,
right,
you know, mom and dad are happy. I mean, that's what
yep,
they want to do. It's not,
right,
but they always have ill will, like, oh, she just wants this from him, or she's just, I've
right.
amount of girlfriend situations that I've dealt with in my time, and the ones that don't inherit anything, they're just kind of bitter through it, but the ones that get tied into the legalities or get added as beneficiaries to accounts and things like that, that's
Mhm.
where I see, just the family doesn't share the same sentiment towards their boyfriend or girlfriends.
Absolutely. And that's why it's so important to straighten it out legally. I will say, since, as you know, uh, probably more than half of my practice is estate planning. Uh, and then the business representation and real estate split the rest of it. Um, a lot of times that situation occurs with an aging male, and he'll show up usually in his 80s, and there's a lady with him that's in her 50s,
Mhm.
and he's wanting to change his estate plan to include her, and his adult children, who are also in their 50s, have the pitchforks and the torches, and they're coming to the castle saying, don't do it, don't do it. Well, if he has his capacity, we really can't say no to him to make the change, but we try to help them think through it and protect both sides in that regard. But that's a very real thing. And unfortunately, elder abuse is a real thing too, as we all know that serve these kinds of clients. And we just have to really be on the watch out for it.
Mhm.
I'm fortunate. I've had very few negative situations in that fact scenario, but I know they're out there. And, our obligation as officers of the court is to determine capacity, not to determine whether they're making a good decision or not, right? Because if they're able to make a decision, that's their decision, not our decision, right? If I
Right.
saw something particularly heinous, I could turn the work away, of course. They're going to go right down the street and find a lawyer that will do that for them.
Mhm.
At least then I can look the adult children in the face and say, I didn't do it, but you've got an issue coming. Yeah.
Oh yeah. Yeah, there's a lot of that out there.
Get with dad. Yeah.
So I want to open it up to the group. If anybody has any questions, feel free to raise your hand. We're going to be wrapping up here in a few minutes as we continue the conversation. But if you had any specific questions regarding real estate, regarding how to, deed it or how to transfer it or anything regarding, come off of mute, let us know. We'd like to entertain your questions. Um, this has been really informative, and I think the whole goal of doing these pre-planning sessions is really to say what can we do, right? Like we talked about, crisis is among us, things are going to happen, it is what it is. But there's the Ladybird deed. I mean, that was probably the best piece of information given. I mean, it sounds like the cleanest way to be able to ensure who you want. We talked about husband and wives, how that will transfer from one to the other upon death. So they would be okay there. Um, I think the part we talked about was you said joint tenancy and tenancy in common.
Yes.
Is that what it is? Okay.
Yep. Little plug. We've got I call it a realtor's glove box guide that
Yes.
outlines all these very simply. If anybody would like one of those, just shoot an email to questions at Rock Solid Law and say you want one, and we'll get one out to you. I think they're very helpful. And, you know, if somebody says the wrong thing, sometimes my mind goes, what? Even though I've done this for, 4 decades, it's really great to have that little cheat sheet right in front of you, especially when it's not what you do all day, every day.
Mhm. Is there any reason, any negative that you see about the Ladybird deed? Like, even husband and wife, yes, I get it. If someone were to die tragically, if they both died in a car accident, then obviously what would happen then, right? It gets transferred
Right.
to, you know but is
Yeah.
there any reason why, just like everyone would not just have a Ladybird deed to have a beneficiary, just like you do for like a bank account, or you have for your life insurance, there's a beneficiary listed. I mean,
Right.
real estate, we don't really have that. I mean, it seems like the Ladybird deed is that registered beneficiary.
If they don't know who their beneficiaries are, or if they're not sure how they want to leave things, then people don't want to put it set in stone, recorded at the public records. Um, and, I
Or
was going
maybe if
to
somebody
say,
were to kill you or something.
yeah, right. It was, yeah.
Hey, if
Um,
I just knock her off, then the property will be mine.
right. Right. It's a little easier to change who gets it inside of a trust, to amend a trust than it is to amend it in a deed, because you've got to record the deed as well. So there's an extra step. But honestly, that's just not that hard, right? So if they came back later and said, oh, little Joe's gone off the rails. We don't want to leave him on the house anymore. We're going to leave it to Sue. That's
Mm,
pretty darn easy to get done. It's not a greater expense than amending a trust.
right. So the Ladybird deed is going to make it public information, but a trust, it would be private.
That's correct.
Right, right. So, and we've talked about that in this group about the trust. Like, it is good that it is private, but at the same time, it's the beneficiary should be educated on what's happening. It's
Absolutely.
great that it's private, but the people that are in it need to know that they are in it and what their roles are and what's going to happen when everything, you know,
Yes,
goes.
I absolutely agree with what you just said. but I want to add the comment that especially for generations before us, a lot of people are very private about their financial information, and they recoil a little bit when you suggest that they should go ahead and let their heirs know what's in that trust, as opposed to just letting it be the after funeral surprise.
Mhm.
So when there are people that are like that, I respect their privacy. That's one of the reasons, as you said, why a trust exists, to keep your laundry out of public view, right? But they we really need to educate the successor fiduciary. In this case, we're talking about the successor trustee. So they know what they're going to do. If nobody else does, they know what to do if you're no longer around, right? And even if that's just call the guy that drafted it, or the gal that drafted it, and ask them what to do, can be part of it. But that they know what happens next is so important. And so when we work with a client to prepare an estate plan, one of the things we offer to do is have an education session with their fiduciaries. Here's
Mhm.
what your parents just put you in charge of, just so you know, and here's how you do that. And any questions you have on that, let us know so we can help you through it. And oh, by the way, if you don't remember this in 20 years when your folks pass, we'll be here. I hope I'm retired by then, but somebody will be running this law firm and they'll answer those questions. So,
Yeah, yeah. And I'm sure it's obvious for most people, but in that Ladybird deed, you obviously wouldn't want to name your children that are underage, right?
right. Yeah. And that's sometimes they're right on the cusp, and people say, go ahead and name them. And if we die, in the next 6 months, they'll have to deal with it. But no, you want people that have legal capacity. You're
Yeah.
exactly right.
Yeah, because then that would turn into a whole guardianship and all the things. And
Exactly.
and then for the Ladybird deed, is it a matter of like similar like a quick claim deed that it does just, obviously you'd want a professional writing it up. It's a more intricate than a quick claim, but do you have to have it notarized? Is it just something that needs to be notarized by two witnesses?
Has to have the same formality as any other deed. You're right. Two witnesses and a notary.
Two witnesses and a notary.
Mhm.
Okay. Yeah.
Yep.
Yeah.
MBA.
I had a question. Is there
Oh, good.
any, when you go to sell that house and you did have a Ladybird deed on it, say I'm alive, it's my house, I have a Ladybird deed to my children, but I'm gonna sell it right before I die. Is there any encumbrance to that process? Does it make it more difficult? Does it just drop off when you go to buy a new place and you have to get a new Ladybird deed for your new home?
Correct, correct, and correct. So the point of the enhanced life estate is that you have the ability to transfer without your children cooperating. And you're correct that once you've transferred the fee simple title to that property, that Ladybird deed is in the past. And if you're going to buy another property, you'd want to consider whether you also would want to have a Ladybird on that so that it will pass easily upon your death. So I know we're running short on time, but I call the Ladybird the anti-King Lear device. I love Shakespeare, and Lear is one of the four great plays: Hamlet, Othello, Lear, and Macbeth. Right? King Lear is the one that gave his kingdom to his daughters. And to jolt your memory, at the end of the play, he was sitting outside of the walls of his kingdom on the dunghill because his kids threw him out. So that's why you don't want to gift your estate while you're still alive, in case they then go, okay, we got everything we ever wanted from you, old man. Bye bye. The enhanced life estate deed, they don't get to do that. And if they get naughty, you have the ability to take them right out just by doing a new one. So you're
Mm.
still completely in control.
Last question.
I have a
What's the
quick,
cost to just do a Ladybird deed for somebody in that case where they don't have an estate plan, but they need to do a Ladybird deed? What's the approximate cost for that? Do you know?
Okay, so I'm trying to get grown up enough where I send you to like the doctor sends you to the lady that's behind the desk, but I know it's under $1,000 to get that accomplished. I don't know exactly. I'd tell you if I did,
Yeah.
oh,
but
so it's,
Alex knows. Yes,
um,
ma'am.
uh, first off, thank you for allowing me to have my lunch while I listened. Um, number two, I really, it's so strange that we are talking about the homestead and all everything that comes with that. As today, I actually had gotten an email from the person that is doing my widow's homestead exemption for the year, as my husband passed 4 years ago, but I sold property, but I didn't buy any property since his passing. So I was able to get that extra homestead exemption on my total assessed value of my home. Um, does that have anything to do with the actual homesteading of my home?
Well, if you didn't have a homestead, you wouldn't need the exemption. Is that what you mean? Or do you mean
Okay.
that would
Okay.
the enhanced life estate deed would not affect your ability to homestead, and neither would a revocable trust.
Okay. Okay.
Either avenue, that is not an issue.
Okay. All right. Thank you.
You're welcome.
Sorry, I have to get this real quick.
John, this was amazing. Thank you so much. And I think really what I keep just saying is that's it. We're gonna use the Ladybird deed. We're good.
Yeah. And
Yeah.
I wish more people would consider it when they're buying, so they didn't have to come back and do it later, because it could certainly be done.
Can they do that? And when they're taking title as for a new property, they could just do the warranty deed with the Hans Life Estate?
Yes, except I would add that there are lenders who don't typically do business in Florida who may not be familiar with them. So we've run into a couple of stone walls there, but otherwise,
There's financing involved.
right.
Yeah.
Yeah.
Yeah, I mean that truly I think is the pinnacle of the real estate pre-planning, you know. Even if it was a husband and wife, I mean, what are the event that God forbid, you know, they were to both die at the same time, then now your real estate is totally, you know, up in the hands of your estate and, you know, probate and all the things.
Right.
Uh, so just taking title with that enhanced life estate just really makes sense. And like you said, if relationships change, if things change over the years, then you just go back and you get it retitled into a different beneficiary. And I mean, at the end of the day, you don't all, you know, yes, it'll be in public records recorded, but it's not to say that it's like, you know, out in some billboard that everybody knows. You'd have to go and look it up and go, you know, so it's not to say that you have to tell your children, hey guys, when I die,
How,
you know.
Yeah.
how would one find that? So let's just say, for example, there is a parent that passes, and the children have been told by the father, "Don't worry, your stepmom has got everything laid out in my will," and and then after the father passed, the children said, "Okay, Dad said you took care of everything for me," and she's like, "There was no will. What are you talking about? I don't know what you're talking about." So in that case, how would one go about finding the will?
Oh, the will, because the will is not recorded. So for every client we serve, we keep an electronic and paper copy. And a paper copy can be proven. It's more difficult than having the original. You're supposed to have the original, but courts are aware that people do destroy documents when they're not favorable to them. So they would accept that with testimony. You might have to find the witnesses and the notary, but absolutely doable. I thought you were going to ask me about the deed, and you look that up just like you'd look up any other deed within the public records, and it would say who the remainder interest was vested in.
Right. So if that was your mom's wishes, or, you know, then they should honestly put it in the enhanced life estate, right? Because then it would say upon my death, my property will be transferred to all the children's names, and there would be no will needed. There would be nothing needed to transfer the real estate.
Yep.
Yep. Banana split. We did it, guys.
Split.
This was a beautiful wrap to our pre-planning session. Thank you, John, for helping us pre-plan our real estate, know how to transfer it in a smooth, uncomplicated way. This is what the pre-planners do, this smooth. So we appreciate your time, John. Thank you for your expertise. And
Sure.
thank you everyone that joined live. And we'll see you on the next one.